Right, good day, you beautiful people. Welcome to the Voice of Reason with me, Andreas, and we are back with another reading of Stephen Yaxley-Lennon versus Jamal Hijazi. Now, after the first video, which did rather well and evidently triggered a lot of SYL's fan club, which I did enjoy thoroughly, we're going to go through. Well, we finished off at D, so let's go start from E to. Let's go E to G because I feel like the evidence is quite interesting. So let's go from 31. Whoop. And here we go. Right. Extent of publication, serious harm to reputation, 31. The defendant has admitted substantial publication of the first and second videos. At the relevant time, the defendant's Facebook account had over 1 million followers. Precise figures for the extent of publication for the first and second videos are unavailable because his Facebook account was closed. However, the defendant has admitted there were around 850,000 direct views of the first video with around 20,000 shares. The relevant figures for the second video are admitted to be around 100,000 and 4,000 respectively, as the claimant was only identified by his first name in each video. The defendant contends that he would only have been defamed to those people who watched each video and could identify the claimant by his name and would know that the comments were directed at him. See KC and MGN Limited 2013. Nevertheless, the defendant has admitted that because of the seriousness of the imputations 1 and 2 and the extent of publications, the requirements of Section 1 Defamation Act of 2013, serious harm to reputation, are met. So, there you go. Yaxley-Lennon admitted defamation. So, defendant's defense, 32. In his original defense, the defendant advanced a defense of truth to the claimant's claim. Subsequently, he applied to the court for permission to amend his defense to add a defense of public interest under Section 4 of Defamation Act 2013. In the second judgment handed down on the 16th of November 2020, I refused that application, but I did permit some minor amendments to the defendant's truth defence. I left open the possibility that the defendant could reapply to rely upon a public interest defence, see paragraph 53, but ultimately he did not do so. 33. In consequence, the only substantive defence relied upon the defendant is a defence of truth under Section 2 Defamation Act 2013. I permitted some further amendments to the defendant's defence of truth shortly before the trial. At trial, the defendant sought to establish the imputations 1 and 2 are substantially true. 34. Following amendment and striking out some paragraphs of the defence prior to trial, the defendant's defence of truth relied upon the following incidents. First, an incident between January-February 2017 when it was alleged that the claimant made an unprovoked attack upon a fellow female pupil, Charlie Matthews. He came from behind, struck her forcefully between the shoulder blades with a weapon in the form of a hockey stick with great force. Brackets, the hockey stick incident. 2. On an unidentified occasion, the claimant is alleged to have acted in concert with 3 young girls in attacking EYW. Whilst the 3 girls were beating EYW, the claimant is alleged to have joined in and bitten EYW on the head. The group attack incident. Now, for anyone who hasn't, I didn't say previously, if there's any names in brackets, it's because those people there are minors who are under 18 and cannot be named legally, so their names have been abbreviated to keep them safe. 3. The claimant is alleged persistently to have bullied a 12-year-old male child, BWI. The claimant was 15 years old at the time. As part of this alleged bullying, the claimant is alleged to have put BWI in an extreme headlock. When another child intervened to protect BWI, the claimant fell to the floor and fractured his arm. He is alleged to have racially abused BWI's mother by calling her a white fat bitch. 4. The claimant is alleged frequently to have been verbally aggressive towards female students and female teachers. 5. On the day of the Plainfield incident, the claimant is alleged to have threatened to stab Baden McLaren. 6. On a separate unidentified occasion, the claimant is alleged to have stabbed a fellow pupil with a sharp-pointed object. 7. The claimant is alleged to have been caught in possession of a knife and screwdriver whilst he was at school. 35. The hockey stick incident and the group attack incident are relied upon by the defendant to establish the substantial truth of imputation 1, albeit without any pleaded case advanced as to the seriousness of any injuries caused to Charlie Matthews or EWI. The defendant relies upon the alleged threat to stab Bailey McLaren to prove the substantial truth of imputation 2. 36. Most of the other incidents relied upon by the defendant were included in his original defence, and the claimant raised no objection to them. They have been expanded slightly by amendment. With the court's permission, the defendant was allowed to rely upon these further incidences because, if he were able to prove them, then although they would not themselves prove the substantial truth of imputations 1 and 2, he might be successful in demonstrating that the claimant had a propensity toward bullying and violent behaviour. In turn, he could rely upon this propensity as leading evidential support to the main incidents upon which the defendant was relying to prove the substantial truth of imputations 1 and 2. I have only excluded from the defendant's defence of truth matters that are either incapable of proving the truth of imputations 1 and 2, for example, allegations relating to the conduct of the claimant's sister, or matters for which the defendant has no evidence in support and therefore no prospect of success. The defendant has been given the fullest opportunity to prove the truth of his allegations in these proceedings. Basically, Stephen was making allegations and still had no proof. Shock. G. The Defence of Truth, Section 2 of Defamation Act 2013. 37. The old common law defence of justification has been repealed and replaced with a statutory defence of truth. Section 2 Defamation Act 2013 now provides 1. It is a defence to an action for defamation for the defendant to show that the imputation conveyed by the statement complained of it is substantially true. 2. Subsection 3 applies in an action for defamation if the statement complained of conveys 2 or more distinct imputations. 3. If one or more of the imputations is not shown to be substantially true, the defence under this section does not fail. If, having regard to the imputations which are shown to be substantially true, the imputations which are not shown to be substantially true do not seriously harm the claimant's reputation. That's not confusing. 38. The imputations that the defendant seeks to prove substantially true are set out in 2829 above. 39. A defendant relying upon a defence of truth must establish the essential or substantial truth of the sting of the alleged libel. The court should not be too literal in its approach. Proof of every detail is not required where the relevant fact is not essential to the sting of the publication. The task is to isolate the essential core of the libel and not be distracted by inaccuracies around the edge, however extensive. By Covert and Associated Newspapers Limited, 2019. The principles to be applied are conveniently set out in the judgment of Nicole J. Depp versus News Group Newspapers. H. The evidence at trial. Witnesses. 40. At trial, the claimant and his father, Jihad Hijazi, gave evidence and were cross-examined by the defendant. 41. The defendant did not give any evidence. He called 5 witnesses at the trial in support of his truth defence. AYQ, Bailey McLaren, BWI, Charlie Matthews and OTP. Each witness had been a pupil at the school at the relevant time. Some of the witnesses were still under the age of 18. I made reporting restrictions to protect the identities of several of them and have used 3-letter ciphers in this judgment to protect the identity of these witnesses. There you go, just like I said. 2. Documents. 42. The other main source of evidence are the substantial school records that have been obtained in relation to several pupils at the school, including, in particular, the claimant, Bailey McLaren, Charlie Matthews and OTP. Both parties have obtained these records, usually following subject access requests made by or on behalf of the relevant pupil. Understandably, before being provided in response to the relevant subject access request, the records were redacted by the local authority to remove information relating to third parties. Before the trial, the defendant expressed concern about some of the redactions. There are some examples where more than one copy of a document has been provided, probably in response to different requests, in which the redactions are slightly different. I am satisfied that this variance is not because of anything sinister or untoward. It is likely simply to reflect idiosyncrasies in the approach to redaction of the records and carried out, probably by different people on separate occasions. There has been no challenge to the authenticity or admissibility of disclosed documents that were included in the trial bundles. Pursuant to CPR 32.19 and Practice Direction 32.27.2, they are to be treated as authentic and admissible. 43. In this case, the school records are, in my judgment, important for 2 main reasons. First, they are contemporaneous records of events at the school. That is not to say that they can be relied upon necessarily as demonstrating the truth of what happened in various incidents. Many of the documents simply record what was said by those who claim to have witnessed or been involved in the events. In places, those accounts conflict. Nevertheless, they are valuable as contemporaneous records of the various accounts. Second, they are important in the assessment of the credibility of some witnesses. See discussions in Luchot vs. Laco. I hope I'm pronouncing that right. And also as explained by Arden, LJ, Wetton, and Ahmed. Contemporaneous documentation is one of the very greatest importance in assessing credibility. Sometimes the importance comes from what is contained in the relevant documents, but equally what is absent from documents or records can also be evidentially significant, as Arden LJ observed. If the judge is satisfied that certain contemporaneous documentation is likely to have existed where the oral evidence is correct, then the documentation may be conspicuous by its absence, and the judge may be able to draw inferences from its absence. Okay, hearsay evidence. 44. Before the pre-trial review held on the 22nd of March 2021, the defendant provided the court and the claimant solicitors with a series of links to video recorded interviews or edited extracts of interviews with various individuals. He gave a general indication that he intended to rely upon these recordings as hearsay evidence. This was an unorthodox method of presenting evidence, not least because it was clearly apparent from the recordings that most of these interviews had been carried out without the subject of the interview being aware that he was being recorded. In one of the interviews, the defendant indicated that he was gathering material to make a program about the case after the trial. 45. I made directions for the proper service of these video recordings and the identification of the particular passages in the interviews upon which the defendant wished to rely as hearsay evidence. The defendant duly served hearsay notices under the Civil Evidence Act 95 in respect of 3 individuals and provided extracts of the parts of their interviews upon which he wished to rely. The 3 interviewees were EYW's mother, another pupil at the school, MYV, and a former teacher at the school, the former teacher. I will not name the former teacher in this judgment, as he was clearly unaware at the time he spoke to the defendant that he was being recorded. Indeed, the former teacher told the defendant that he was not permitted to speak about events at the school, so I consider that it is highly unlikely that the former teacher would have given his consent for any interview to be recorded. 46. When assessing hearsay evidence, the court's task is generally to determine the weight, if any, to be attached to the evidence. Section 4, Civil Evidence Act 95 provides. 1. In estimating the weight, if any, to be given to hearsay evidence in civil proceedings, the court shall have regard to any circumstances from which any inference can reasonably be drawn as to reliability or otherwise of the evidence. 2. Regard may be had, in particular, to the following: whether it would have been reasonable and practicable for the party by whom the evidence was adduced to have produced the maker of the original statement as a witness. B. Whether the original statement was made contemporaneously with the occurrence or existence of matters stated. C. Whether the evidence involves multiple hearsay. D. Whether any person involved had any motive to conceal or misrepresent matters. E. Whether the original statement was an edited account or made in collaboration with another for a particular purpose. F. Whether the circumstances in which the evidence is adduced as hearsay as such as to suggest an attempt to prevent proper evaluation of its weight. Not easy with small writing, I'll tell you that much. 47. Miller and Associated Newspapers 2012. Whoop. Don't know what happened there. 36. As the authors of Phipson on Evidence, 17th edition, say at paragraph 29-15, the Civil Evidence Act is not intended to provide a substitute for oral evidence. The basic principle under which the courts operate is evidence is given orally with cross-examination of witnesses, and the admission of hearsay evidence is and should be the exception to the rule. Caution should be exercised before tendering important evidence through hearsay statements. Hearsay evidence is better used where the evidence is peripheral or relatively uncontroversial. 37. It seems to me that selective snippets of hearsay from individuals who have not been called, particularly where it has been cherry-picked from material which casts it in a different light, provides an obviously unsatisfactory evidential basis upon which to invite a court to find facts and or draw adverse inferences, whether as to the conduct of those individuals or anyone else. In a sense, it is Hamlet without the prince. There may be cases where hearsay evidence and or the contemporaneous documents in combination provide persuasive evidence, but in my judgment, they did not do so here. It is no answer to the problematic nature of the hearsay evidence relied upon in this case for the defendant to suggest that it was open to Mr. Miller to call the relevant individuals himself, or required their attendance for cross-examination. The burden is on the defendant to prove its case, and the tendering of hearsay evidence which lacks weight for various reasons doesn't cast any burden on the claimant to require the witness concerned to be called for cross-examination, let alone for the person concerned as his or her own witness. The judge's approach was upheld on appeal 2014 in the EWCA. 48. Relying on the same principle in Hurani and Thompson in 2017, Warby J stated as a general proposition that it is unsatisfactory to introduce important evidence by means of selective extracts from hearsay written statements. 49. In respect of the hearsay evidence from the child, MVY, there is an additional consideration. Section 5 Civil Evidence Act 1995 provides, hearsay evidence shall not be admitted in civil proceedings if or the extent of that is shown to consist of or to be proved by means of a statement made by a person who at the time he made the statement was not competent as a witness. A. Child shall be treated as competent as a witness if he satisfies the requirements for Section 96, Part -2, A and B of the Children's Act 1989, conditions for reception of unsworn evidence of a child. 50. Section 96 of the Children's Act 1989 provides, the child's evidence may be heard by the court if, in its opinion, A. he understands that it is his duty to speak the truth, and B. he has sufficient understanding to justify his evidence being heard. 51. I have watched again the extracts from the recordings of the interview with EYW's mother, MVY, and the former teacher. It is quite apparent from the recordings that none of the individuals was aware that he was being recorded. 52. I will deal with specific points that arise on this hearsay evidence when I come to deal with the various incidents, but as a general proposition, the court must be cautious when assessing the weight that can be attached to the evidence that has been obtained by covertly recording an individual. There may be circumstances in which the surreptitious recordings lead to the witness giving a candid and truthful account that he might not have been prepared to give if he thought that her words were on the record. On the other hand, covert recording may give rise to the risk of the witness not telling the truth or embellishing her account. As I noted at the pre-trial review, individuals who are covertly recorded by the defendant may be genuinely shocked to discover that what they had said to the defendant has been presented as evidence to the court during a high court libel trial. Now, we're going to leave it on that one there because we've got the witnesses to go through next, and oh boy. See, now, a lot of his fanboys and girls will sit there and go, like they did in the previous video, oh, you need to see the film. Oh, you need to see these people actually admitted this. These people said that. Now, this is the reason why the judge threw that evidence out. It's because it's not credible. It's because these people's conversations weren't fully recorded. It's funny how a lot of people in the comments refused to answer because they couldn't answer a very simple question. In that silenced film, why did he not show you the entire conversations? It's because the man has something to hide. He has an agenda to push and a narrative to force down people's throats. Now, what you'll see in the next video with the witnesses is incredible. It really, truly is. You will see the extent of what SYL will do to get his arse out of trouble that he got himself into.